All right, good afternoon. It is Let's Talk Live. We are a little bit delayed with our show this week because we had work and duty called last Friday, so we had to roll the show to today, Monday. But we are happy to be here with you guys. We're just gonna let some other viewers join us before we get started and jump into really the meat of our program today, which will be focusing again on immigration and giving you some updates since we last had our last show back in January on immigration. There's been quite a few developments in that area, so I wanted to, take some time to chat about what's going on, what to expect, where you guys or listeners or viewers or clients, just give you some quick tips and updates as to, what exactly is going on in the immigration arena right now. Um, so we have quite a few people jumping on. I see you guys. Thank you. Hi, Instagram. We're live on Instagram, Facebook, YouTube right now. Share this with anybody. It's HAWM Law. Let's Talk Live. As you know, we practice criminal defense, immigration, family law. Our focus for the program today will be immigration. Want to get started with our legislative updates because that's kind of the big hot topic. What's going on? When is the government going to drop this new law out that, but I want to assure you, at this time, there are no new immigration laws. There are several bills since January with a new 117th Congress. There are about 7 or 8 immigration bills that are making its way through legislature. The major one was the U.S. Citizenship Act of 2021, or H.R. 1177. That was President Biden's huge immigration reform bill. It is still in the House. It is at various committees being reviewed, marked up. They're going to cross through things, they're going to add things, they're going to delete things, they're going to do a lot of things to that bill before it actually makes it out of the House. So it was introduced back in February. It is not currently law. So if someone is telling you that there is a new immigration law out there that can get you a green card and you're able to get your green card on your citizenship if you haven't had it for a while, that is in fact not correct, right? This is still not an actual law yet. It has to pass through the House and then it has to make its way through the Senate, where we expect it to have, stronger opposition than it will in the House, and it hasn't even made it out of the House. Outside of that, there are several other smaller bills that take some components from the Citizenship Act. Right now, we're looking at H.R. 6, the Dream and Promise Act. That bill has already passed. It was introduced in March, and it passed with bipartisan support in the House, and it's currently in the Senate. It's been read twice in the Senate, and it's now at the committee level. So it is making more progress than the Citizenship Act. It will require 10 senators to vote with the entire complement of 10 Republican senators to vote with the entire complement of Democratic senators in order to move this bill to the president for it to become law. However, I don't anticipate that it may make it all the way through in its entirety. It's going to be marked up, it's going to be edited, it's going to, be addressed. One of the major deficits I think there is in this particular bill, why it will struggle in the Senate, is that it lacks enforcement. But what it does is really creating a path to citizenship for our dreamers and TPS holders. That's the main component of this bill. It would grant dreamers, which are children who came in to the U.S. relatively young. They remained in the U.S. for a significant period, but they were out of status. Currently, a lot of them qualify for DACA. It's going to increase the age because one of the requirements for DACA is that you had come in by the time of 16. But this wants to increase that age to 18, so it will capture more young adults who immigrated to the United States at a young age and are currently out of status. We'll give them conditional residency status for 10 years. So it's a longer path to citizenship. once they've been conditional residents for that 10-year period, after that they would be able to apply to remove the conditions for the green card, provided they meet certain requirements. And particularly, in order to become a full green card holder under this proposed House and Dream and Promise Act, they would need to have acquired a degree from a U.S. institution of higher education, completed at least 2 years in good standing in a bachelor's or higher degree program, or career or technical college or something. You have to have at least 2 years of good standing there, or you've completed at least 2 years of military service and you were honorably, and you may have been honorably discharged. In addition to that, you have to have been employed for a certain period of time. They want you to be employed for a period of totaling at least 3 years, or at least if it's been less than 3 years that you've had employment authorization, at least 75% of that time you have been employed with your employment authorization, right? So that's the Dream and Promise Act. The other component, of course, is for TPS holders and individuals that have deferred enforced departure. And what it really saying is that if you've been in the United States for a period of 3 years before enactment of this particular bill, before it becomes law, and you had TPS, you would be eligible to get conditional residency under this program and then be on a path to citizenship, right? So that's the American Dream and Promise Act. And it really does look promising to the extent that it's already passed the House with bipartisan support. However, they still have some ways to go in the Senate, and because the Senate and House have to pass identical bills, so it may go back to the House at some point before it actually makes it to the president's desk to become law. We're hopeful that this will bring the needed relief for our dreamers. It's been a long time, since DACA was implemented, and DACA has really just been a band-aid over a worsening mood for our dreamers. So if this Congress can get something done that will give dreamers, a permanent, stable footing in the United States, that would be absolutely wonderful. The other bill that's making its way through the legislature and did also pass with, overwhelming bipartisan support is the Farm Workforce Modernization Act, right? And this is really addressing the needs of our farms and agricultural industry, and to modernize the employment aspects of the farm workforce, to secure that American farmers have stable employment and the workers are protected, and therefore also not affecting the wages and the working conditions, and make sure that there's protection for individuals who are coming in as farmers, in the United States. And it will also provide some increased visas in the H-2A program, which is the agricultural worker program that has, been oversubscribed for decades. So hopefully this will also put individuals on a path to having a green card once they've established that they've been farm workers in the United States for a certain period of time. Also making its way through the Senate. It is at the Senate Judiciary Committee for evaluation, and it will get marked up. It will make several rounds before it actually, if it actually becomes a law, because that is the biggest issue. We have to get through both the House and the Senate for any bill to become law and signed off by the president. But these seem to be the most promising of all the immigration bills currently in the 117th Congress that's making its way through. So, like I said, I want to reinforce the fact that there is no new immigration law out there. There is nothing new that you would be able to use right now to get a green card. If you are without status in the United States and you want to obtain status, the best thing that you can do at this time is really to contact an attorney to see what avenues are available to you under the current immigration regime, because there's no guarantee that there will be something new in the new there will be a new law in the future. There is no guarantees of that. So it's best to try to work, like I always tell clients, I like to work with the devil I know, because sometimes the devil you don't know is going to be harsher. And a lot of times immigration reform, comprehensive immigration reform, that is, do come with harsher, stricter penalties for immigrants coming in. So if you have the ability to obtain a green card or some status right now, I suggest that you contact an attorney, discuss those issues, what your case-specific issues are, and try to obtain that status now, right? Next big topic for us is TPS. Temporary protected status was granted to Venezuela, our neighbors to the south. You know, if you're from the Caribbean, it's our neighbors to the south, as well as the south of Florida too. But TPS has been granted based on the violence and the political issues that are existing in both Venezuela and Burma. TPS has been granted, and right now TPS has been granted for 18 months. So it's going to be the initial period of validity will be March 9th, 2021 through September 9th, 2022 for TPS. In order to obtain TPS, you must be a national of the country, Venezuela or Burma, or a person who last resided in that country, but you are not a citizen of that country and you don't have nationality elsewhere. You must have maintained continuous physical presence in the U.S. since the date TPS was issued, which was March 9th for Venezuela. Burma came on a little bit later on. So I'm going to focus on Venezuela, but it's still the same rules. There may be some additional, changes with the dates for Burma, but it's the same concept. You have to have continuous residence. So you have to have both physical presence in the country and continuous residence, being in the United States with an intent to remain in the United States. The initial registration period is currently open. You definitely have to apply for TPS if you are eligible within the initial registration period. If you miss that initial registration period, there are late filing options, but it is immensely harder to late register for TPS. So you want to make sure you submit an application for TPS within the initial registration period, which is currently running right now all the way through September 5th of 2021. There are some ineligibility requirements, rules basically. It says you cannot be convicted of 2 misdemeanors or 1 felony. So in order to get TPS, you cannot have a serious criminal history, which according to, for TPS purposes, is 2 misdemeanors or 1 felony. You're also not inadmissible for national security grounds, as well as your security rate. You're not a threat. You don't engage in espionage, spying against the United States and things like that. And you're not subject to any of the mandatory bars for asylum. With TPS, you will be able to get travel authorization, so you can apply for advanced parole. However, I do advise that if you have a pending asylum application as well from a TPS country, it's probably going to make your asylum case immensely harder if you were to travel back to that country from which you fear persecution, right? So an asylum application, if approved, ultimately will give you a green card. TPS is just temporary protected status. But as long as you do not yet have a green card, if you do not have a green card in hand, you should apply for TPS. It's advisable that you obtain TPS. You can have TPS, you can have asylum application, you can have a green card application, all of those things pending at the same time, right, while you have TPS. So I encourage you to obtain TPS, apply for it if you are from one of the eligible countries for TPS, and make sure not to miss that initial filing deadline, registration period if you can. Prior to the issuance of TPS for Venezuela in particular, the president issued what's called by proclamation a deferred enforced departure for Venezuela. It is slightly different than TPS, and currently the registration period, there is no registration. So if you're in the country, you're from Venezuela, you are automatically covered by deferred and enforced departure. You do not have to register for this, right? The period of validity for that will run from January 20, 2021 all the way through July 20 to 2022. So it's a little bit shorter than TPS. So if you can apply for work authorization with the deferred enforced departure. So for example, if you didn't apply for TPS, you'd get a work authorization just the same. However, right now, based on the period of validity, you have about 52 days less work authorization through the deferred enforced departure program versus TPS, right? But both do provide you with the ability to travel at some point. Next issue I want to touch on, I know there's a lot of different topics going on. If you have any questions that you want me to address here while we are live, definitely chime in, put it in the chat. I will try to take a look at it and definitely respond while I am on the live, because your question might affect other individuals watching the program as well. So if you've applied for adjustment of status, recently the public charge rule, there was a new public charge rule that was issued back in 2019 by USCIS, Department of Homeland Security, that has officially, died, meaning that the government has said they will no longer pursue any appeals challenging the validity of the public charge rule and are going to officially withdraw the rule. So what does that mean for you if you have a pending application? If you have a pending application and you had a request for evidence stating that you need to produce documents related to the public charge rule, you will not have to produce those documents, right? For my clients in particular, I still respond to the request for evidence, just letting them know, hey, this rule no longer applies, even though you sent me that request, and that usually gets them starting to work on the case again. Otherwise, the case is kind of just sitting, waiting for that request for evidence to be responded to, right? If you filed an application with the relevant documents for public charge responding to it, and you're going to be set for an interview, or your case is currently being adjudicated by USCIS, they will ignore all portions of the application and the supporting documents related to the public charge rule, right? I also want to point out, it does not mean there isn't a public charge rule in place. This is just the new rule. It is no longer going to be enforced or going to be pursued by USCIS. We've always had a public charge ground of inadmissibility, right? And that is still in place. You still have to have a qualified sponsor. Your petitioner who's filed an application for you must be a sponsor. If that individual does not make sufficient income, you can also have a joint sponsor, right? However, you're not trying to combine the income that your sponsor and your joint sponsor make in order to meet the threshold. This joint sponsor must independently of the petitioner have sufficient income for their household size and also to add you as a dependent, right? And they're looking at the last tax return, who they claimed as their dependents, are they married? And then they look at the Health and Human Services poverty guidelines to determine whether that is sufficient income to sponsor an individual in the United States. You have to make at least 125% of the federal poverty guidelines. Roughly that number is about $22,000 for a two-person household, and you're adding, and these are rough numbers, you're adding about $5,000 for each additional person in your household in order to meet the sponsorship guidelines, and they would have to do an affidavit of support, right? So, but good news there, it makes our jobs easier, it makes the adjudicators' jobs easier, because we are no longer having to address the issues of the public charge rule. If you're just listening in, if you're just tuning in, you're watching Let's Talk Live with HAWM Law, having an attorney when it matters. We're here for for your legal needs when you're talking about criminal defense, immigration, family law, personal injury. Those are the areas that we focus on and provide consultations on. So if you are in need for a consultation in any of these areas, please give us a call, 407-802-3223. We offer free and low-cost consultations depending on what area you need to be addressed. So there is no excuse to get competent legal advice for any of your legal matters. So please definitely tune into that. The next area that I want to touch on before we go off the program is how to deal with a delayed immigration case, right? In the last 4 years, we've seen the immigration system really slow down. It really has grinded to some extent almost to a halt. Case processing times have doubled. We've gone from 3 months, 4 months to processing a citizenship case to sometimes well up to a year or more for an adjustment of status case based on a family petition. We've seen those processing times go from 6 months all the way up to 18 months or more. The U.S. government, there are published processing times to determine whether or not your case is delayed or whether it's within the normal processing times. So what you want to do is you want to get on USCIS.gov, check your case status to see what's going on, and you haven't missed mail, because unfortunately, our U.S. Postal Service, which is what USCIS uses to deliver documents or your case-related information to you, has been less than reliable in the last couple months. So you want to check your case status to make sure you haven't missed anything. If you haven't signed up for the account online, you want to go ahead and sign up for that account, because some of those documents may be available to you on the USCIS online account. Once you've checked your case processing times online to see what's going on with your particular application, you want to find out, is it within the range? Because they give you a range. It says this case could take 18 months up to 30 months, right? And if it's within that range, you're within normal processing times, and USCIS does not consider that to be a delayed case. If you're outside of a range, then meaning your case has been pending for longer than the published case processing times, usually you will have the ability to submit online a case inquiry. And we suggest that you do this because you have to develop the track record as to following up and being diligent at getting your immigration case reviewed. So you submit that case inquiry through the USCIS.gov website. Submit a case inquiry if your case is outside normal processing time. USCIS will usually say they will provide a response on your delayed case within 30 to 45 days. If after that time has passed and you still have not had any success or any movement on your case, another tip that I would provide you is to file what's called an ombudsman request. USCIS has an ombudsman office that is not part of USCIS, but it is another government entity that is designed to be a liaison to get cases resolved timely with USCIS. So if your case is outside of that normal processing time, you've submitted an inquiry to USCIS through their online system and you have not gotten a response, your next step is to file an ombudsman request, right? Unfortunately, because of how many cases are significantly delayed, the ombudsman's office says that I believe their processing time is 45 to 60 business days, not calendar days, business days. So it could be quite some time before you get a response from the ombudsman office. And usually they will either get USCIS to look at your case, start moving the case forward, start processing the case, right? If you are still unsuccessful with having your case looked at, the next best option, of course, is to file a federal lawsuit against the government, right? Because the government, USCIS in particular, what we're talking about here, has an obligation to, one, act on your cases and make correct decisions. So if you have an issue where your case is not being timely addressed, it's outside of USCIS's own published timelines and it's significantly delayed. As a person who has paid your money to the US government to have your case adjudicated by the government, you also have the ability to file a lawsuit in order to force them to take action on your case, right? In these types of cases, they can be mandamus cases or cases under the Administrative Procedures Act. The court is not telling USCIS to approve your case and give you a green card. No, what the court will instruct the government agency to do is to make a decision on your case within a certain period of time. And usually that will happen very quickly, right? Because in some cases, the government may be responsible for paying your attorney's fees. So usually once a federal lawsuit is filed on a delayed immigration case, we usually get responses. But sometimes cases can be delayed because there are issues with the case, right? And I can tell you what my process is. I like to look at who filed your case originally, right? What's the status of that? Because I've had issues where, individuals come to me and say, my case has been significantly delayed. It's been 3 years. I haven't gotten a decision. I went to my interview 3 years ago. But then you may have used an individual, could be an attorney, or you may have used a notary public or a notarial or some individual to prepare your immigration documents. And when you look further at that, that individual may be prosecuted for immigration fraud, thus causing the agency to red flag your application. Doesn't mean that your application is fraudulent. It just means that we need to address those issues before we file suit and to make sure that your case is properly in order and that there was nothing done incorrectly with your particular case, and we can get it back on track, right? And we do this all the time. So, and we've had a tremendous success with getting individuals their citizenship where their case has been significantly delayed. They've gone to their interview and USCIS has taken months, because under the Immigration Nationality Act, you have 120 days from the date of your interview to decide your citizenship case. If you're beyond that 4 months, then your case is delayed for citizenship and we can file it federally, right? With your adjustment cases, if your case is, 2-3 years, a year past the published processing times, that's a significantly delayed case, and we can probably try to get it addressed through federal process, all right? I don't see any questions. I don't see any issues. Let me just check here. Thank you for tuning in with us with Let's Talk Live. We hope it was helpful to you as you're navigating the immigration process. We hope that you will continue to tune into our programs. We'll have another show later on this month, and we have lots of new content coming out. So definitely try to follow us on Instagram, follow us on YouTube, because we have a lot of information to educate the public about all the different practice areas we do here at AJWM Law. It is our passion to serve you, our clients, and the public. Thank you for tuning in.